Hi, I'm attorney Gregory Dell, and I'm here with attorney Rachel Alters. How are you, Rachel?
I'm good, thank you. How are you?
Good. And I want to discuss with you today kind of an overview of the Lincoln Financial Disability Insurance Company. Now, obviously, they also sell other products besides disability insurance, but what we focus on is disability insurance claims. And to give an overview of this video, we're going to just touch on, because we have other videos talking about the specific things that Lincoln does, but we're going to talk about applications, appeals, lawsuits, and different ways in which we've seen Lincoln handle claims as compared to how we've seen some of the other companies. Because you know that every company has their own nuances, and the fact that we've handled a couple hundred claims with Lincoln, we know exactly what to expect from them.
Correct.
So let's get started talking about overall about Lincoln, kind of the merger recently where they bought Liberty Mutual. What's your overall view of Lincoln as a company?
Well, Lincoln as a company, I mean, they are a very large insurance carrier, and you know, as a company before they purchased Liberty, they were large. Now they're huge, and I think that they're, in my opinion, dealing with them versus dealing with Liberty separately. Lincoln seems to be a little bit overwhelmed with their claims processing. They're behind a lot with deadlines, and you know, I don't know that they have enough employees to handle all of the Liberty claims that they inherited. So that's just my personal experience. I don't know that for fact, but it seems like a lot of things are slipping through the cracks, and a lot of deadlines are being missed, and you know, they have a lot of excuses, and they're asking for a ton of extensions.
Okay, so I've noticed that as well, that merger may not be going as smoothly as it should be, but obviously they're going to work that out and eventually get to the point where they're smooth. I mean, it wasn't always the history with Lincoln where they weren't handling their claims smoothly, but in terms of fairness, I tend to find them to be, I think, a middle of the road type company, you know, compared to the ones that are really bad and the ones that are much better. Their claim reviews are on average. They're usually on time with what they do, but they can be very tough when it comes to evaluating claim and making a claim decision.
Correct.
So in terms of applying, usually with Lincoln we see 99% are group ERISA governed disability policies. Would you agree with that?
I would.
Okay, and so for people who that means you have your policy from your employer, you're receiving it as a benefit, and that means your claim is going to be governed by ERISA, which means that you have to comply with all the ERISA regulations, which makes it very specific about what Lincoln has to do.
Right.
So let's talk about, in terms of when someone applies with Lincoln, what kind of time frames you usually see from when the application is submitted until you get a decision.
It varies, obviously. It depends on how complex the person's medical records are, and if tax returns and all of the financial information is involved. It just depends on how much documentation that Lincoln requires. But usually, you know, within 45 days, there should be some sort of decision, or at least they're going to say, we need more information within that time period. That's my experience.
And then what are the common definitions of disability that you see within a Lincoln financial disability policy?
Well, usually, I mean, the definition of disability usually begins with an ONOC definition, which is, can you do your own occupation? And the definition is usually, they're not all exactly the same, but can you perform the material substantial duties of your own occupation? And then they define your own occupation as it's defined in the national economy. So it's not your occupation as you do it every day at your office, but you know how ONET, or the Dictionary of Occupational Titles, will define your occupation. So that's how they usually start out. And then after 24 months, the definitions normally change to whether you can do the material substantial duties of any gainful occupation. And they define that usually also as, you know, basically, can you do a job sitting at a desk 40 hours a week? And some of them have an income component to them where they do require you to be able to make either 80 or 60% of your salary. It's not always that income component is not always included. So every policy is different. So that's why you have to be very careful and make sure that you have somebody who knows what they're doing, reading your policy and explaining what the definitions of disability are.
Do you often see a mental nervous limitation in the Lincoln financial policy?
I want to say almost always see a mental nervous limitation in those policies. So there's a 24-month mental nervous limitation, which means that you have only 24 months in the lifetime of the entire policy to collect. So if you have any kind of mental nervous condition, whether it's depression, anxiety, bipolar, schizophrenia, usually schizophrenia, sometimes that's an exclusion,
right.
The company will only pay you 24 months. If you have a physical condition that's disabling, on top of that, sometimes you can get beyond it. It would just depends on the language of the policy.
Okay, so we've helped hundreds of people apply for the Lincoln Financial benefits, but the next stage that I really want to discuss where we help the most people is when it comes to the person that's been denied their long-term disability benefits, and then we have to submit an appeal. Something that I find very unusual about the Lincoln Financial appeals, I don't believe we saw this on the Liberty Mutual side, is that they usually require you to do 2 appeals if you don't win after the first appeal.
Right.
That's correct?
Yeah, that's correct. They require 2 full administrative appeals before you can take them to court.
Okay, do you find with Lincoln in terms of how they go about doing their appeal, do they rely on their own in-house doctors and nurses, or do you find that they go to third-party companies and will do paper reviews, or will they request an independent medical exam? What do you usually see from Lincoln?
It depends. I think it depends on the claim. I think the higher the benefit amount, the more they tend to go outside and send the claim in for an IME or a functional capacity evaluation. A lot of times if the benefit amount is a little bit lower, they stick with their in-house peer review physicians. I don't know if this happens every time, but they do have in-house peer review physicians that review the records, and then they make the determination as to whether they agree with the claimant's doctor, which most of the time they don't.
Okay. And then a lot of people always call me and say, what do you see as the #1 reason that Lincoln is denying claims? And my #1 reason, you could think of what you see maybe as #2 if I took your #1 as if we're playing Family Feud, is that they say that your subjective complaints do not match the objective evidence that we see in the file.
Right.
And basically what that means is that we see that you have all these complaints, but we don't see that you have an MRI, an X-ray, a diagnostic study, blood work, any kind of other objective study that may be relevant to what your medical condition is that would support the complaints that you have. And because of that, we're denying your claim. Now that is a typical nonsense denial unless there's an objective evidence requirement in a policy, which I don't believe Lincoln usually has. And because there's no measure for pain necessarily, and the level of your pain is not going to match some unknown objective test that may not be available. So we deal with that type of denial, if that's what you have, almost every time.
Well, yeah, and especially if you have a condition such as fibromyalgia or chronic fatigue syndrome, which are real true conditions, but unfortunately there are no objective tests that exist at this point to test whether or not you have these conditions. So they do base those diagnoses on self-report. And it's basically a diagnosis of elimination too. So they test you for everything under the sun, and then if you don't have those other conditions, they assume you have the fibromyalgia or chronic fatigue syndrome. But the insurance carriers oftentimes will say, you know, we're not going to approve your benefit because you've based all of your complaints and the doctor diagnosed you based on your self-report, not on any objective test. So it's frustrating because there's really no way to get around that sometimes.
In terms of the second most common thing that I usually see is that they've run video surveillance on the claimant.
Right, happens a lot.
And why is that a basis for a denial?
Well, because oftentimes the claimant, if, you know, especially if you did not use a lawyer to help you do the application and go through the application process, a lot of times the claimant doesn't know that you can't write down on an application, I can't, you know, ever sit for longer than an hour. I can't be in a car for more than 2 hours. I could never lift more than X, because when you put yourself in that little box, if you get caught on video sitting for more than 2 hours or picking something up on one occasion that's more than were allotted, then they will say, oh, this person is not telling the truth. They're exaggerating, they're clearly capable of working, and they deny you based just on that alone. So we're very careful how we fill out the applications to make sure we, you know, are more broad and generalize more as to what you're capable of doing instead of putting you in a box. But they will try and get you on video claiming you can do something that you claimed you couldn't.
Okay, so we have another video where we talk about some tips about how to handle a Lincoln Financial appeal, which we encourage you to watch that video and call us with any questions that you may have. The last topic I want to discuss about Lincoln Financial is the remedy after an appeal. You've exhausted 2 of the appeals that they require. Now, what are the options and how do we go about handling that as a law firm?
Well, after the second appeal is denied, then there's no further appeals allowed. So the next step is to file a lawsuit in federal court. And normally, because these are group policies, they're filed under ERISA. And once they're filed, the Lincoln Financial has the opportunity to answer the complaint, and then a judge will enter a court order, which basically gives us a list of dates of deadlines for mediations and trials. And in the meantime, we work on trying to get a fair settlement for the client. A lot of times the client's obligated to come and mediate the claim because the court orders that. And if the mediation is successful, then the case is settled. If it's not, then we can end up going to motion and fighting in court. And when you go to court, I don't know if you want me to discuss this, but when you do go to court, you're in front of a federal judge. The judge does not, unfortunately, get to meet the claimant. The judge basically reviews the claim file and my motion, our motion, and Lincoln's lawyer's motion, and determines whether or not Lincoln was arbitrary or capricious in the denial of the claim. So basically, in layman's terms, that means did Lincoln have even one reasonable basis to deny the claim? If the court finds the answer is yes to that, then the claimant loses and Lincoln wins. If the court finds that Lincoln was arbitrary and capricious, then the court will most likely award the back benefits that the claimant is owed, not always, but most likely. And then they remand the case back to Lincoln for another review to see if the claimant's still disabled, and then it can go on from there.
Right, I think the bottom line is, and again, we have another video talking about, getting into more detail about what ERISA is, what that standard of review means. Is it de novo? Is it arbitrary and capricious?
Right.
Like you said, but the bottom line is our goal is to try to get you put back on claim. However, what happens in a lot of these claims, as you know, is that they often will make a settlement offer to you that is a certain percentage of what you would be owed over your lifetime, or over the duration of the entire claim,
Right.
which is usually age 65 or Social Security retirement age. And so what very often happens is that they offer you a certain sum of money where it may not be worth the risk of trying to roll the dice with a federal judge to make a decision to possibly try to double or triple the amount of money that you would get if you were to win. Plus, as you were indicating, it can often take 18 months to 3 years to get to a final judgment following an appeal of a final judgment, and that's a long road for a person who's not getting paid any money at all unless they happen to be fortunate enough to be getting Social Security disability at the same time. So it's very, disability carrier makes it challenging for the claimant to continue to try to support themselves and live through that period of time. Well, one of the things that we do is we try to get a resolution and an offer very expeditiously within a couple months of filing a lawsuit, and we're able to get that as a law firm because of the fact that we've handled so many claims against Lincoln that they know that if they go the distance with us, that they're going to rack up hundreds of hours in attorney's fees, and if they do lose, they're going to be looking at another couple $100,000 in attorney's fees that they're going to have to pay. We're more interested in trying to get the claimant paid up front than trying to prolong this and rack up attorney's fees that Lincoln would eventually have to pay. So, so it's really in the best interest of the client to try to get the case done in as quickly and as reasonably a manner as possible, and that's what we'll discuss with you, based upon your case. So overall, in summary, we welcome you to please give us a call to discuss your claim, no matter if you're applying, if your claim has been denied. Sometimes, occasionally, they'll offer you a lump sum buyout offer, where if you're a person on claim, they may send you a letter saying, would you like to have your claim bought out? Whatever your situation is with a Lincoln claim or a former Liberty policy, give Rachel, myself, any of our disability lawyers a call, and we look forward to the opportunity to help you.